Mr. Wakoko, sorry. I almost forgot Mr. Wakoko.
Thank you,
Mr.
Honorable
Wakoko.
Chairperson and members. Thank you so much.
Yes.
Honorable members of the tribunal, we responded to the application and the appeal by filing our response in the style of a replying affidavit. It is sworn on 18 February 2026. Chairperson, it is our position that we have been invited to court prematurely in the sense that under Section 40 of the Political Parties Act, the Register of Political Parties has not made any decision that could make a party member or a political party for that matter drag the registrar to court. So, Honorable Chairperson, as the tribunal retires, I invite the tribunal to look at Section 40, and further, I invite the tribunal to look at Section 20 of the Political Parties Act in terms of the change of party particulars, which it is our contention that we are not in receipt of that particular change, and as such, no decision has been made. I rest at that, Honorable Chairperson.
Okay, thank you, Mr. Wakoko. I apologize. I almost forgot you because you said you have no dog in this fight. That's why I was almost forgetting you. We now can go to the rejoinder by senior counsel.
Thank you. Thank you very much. I'm just organizing my notes here. Yes. Honorable Chair and members, Mr. Makori began, first of all, by unfortunately completely misconstruing the submissions I made in relation to who the aggrieved party was. My submissions are not questioning who the aggrieved party is in this case. Submissions were questioning who the aggrieved party was in relation to the allegations of misconduct raised against complainant, Secretary General of ODM. In fact, this actually ties in with the closing remarks made by my learned friend, Honorable Kajwang. Because, as he very helpfully pointed out, it would be a fallacy, that it would be incorrect to claim that organ conducting administrative proceedings is the complainant. And yet, looking at the affidavit of Halima Daro, which disclosed the particulars of the allegations raised, is the only source of allegations that the complainant has. And it is being raised by an official of the party on behalf of the party. It doesn't name whom the allegations have been made by. And so therefore,
the irresistible conclusion is that it could only have been members of the NAC who were aggrieved,
made allegations of misconduct against the complainant, not disclose them until 10 days after the resolution to remove him had been passed. My learned friend Mr. Makuri's reference to Article 88 of the Constitution does not assist the first respondent in any respect, Your Honor, for the simple reason that provisions of Article 88 and its reference to internal dispute resolution mechanism cannot operate to cure ultra-virus actions, any party official or any party organ. Article 88 of the Constitution of the ODM is only useful and invocable where it relates to proceedings under the Constitution of ODM that are lawful. Mr. Makori has submitted that the resolution of the 11th of February 2020, which purported to remove the complainant, came up in the agenda as a matter arising. Chair and members, that is a statement made from the bar. There is no evidence that they have produced to confirm that this was the case. On the face of the resolution itself, nothing suggests that it was a matter arising. Evidence before the court, including the text messages from the executive officer notifying the NEC members of the meeting, speak for itself. There was absolutely no notification, even to the members of the NEC, there would be any deliberation under Article 74 on the conduct of the complainant. Mr. Makori has stated that Article 74, Sub-Article 3 of the ODM Constitution provides the complainant with a right to be heard. That is true, but what he is avoiding, Article 74(3) places an obligation upon the NEC to notify the complainant prior to the making of any resolution. This is the NEC's breach of this sub-article by failing to notify the complainant prior to the resolution, resulted in the NEC's proceedings being rendered an illegality. Council has also referred to the internal appellate architecture, which he claims has not been invoked. Here again, I must repeat that the only foundation of this submission, the doctrine of ostrich equivocation. No reference whatsoever has been made to any provisions of the ODM Constitution relating to this internal appellate architecture. Because, with respectfully submit, there are none. Once the NEC makes an executive decision under Article 74, Sub-Article 2, it results in the removal of office of the person who is the subject of resolution. National Governing Council, the function of receiving, considering, adopting reports from the NEC, not its executive decision. National Delegates Conference, meeting every 5 years, has a function of electing into office bearers. 5 years. not reviewing executive decisions of the NEC. Mr. Amondi has invoked Latin phrases suggesting there should be consideration of dishonorable actions and illegalities on the part of the complainant, specifying what would have been the infraction specific to ODM's constitutional provisions. More importantly, when would he, the complainant, have been notified of these infractions and of an intention to deliberate on them under Article 74? Learned Friends' submissions are devoid in that respect because it is clear that the provisions of Article 74(3) were breached by the NEC. To state that it is in the public interest that political parties are disciplined to engage in the programmatic policy formulation, Council has not shown how this public interest of discipline entitles the first respondent to act in breach of its own constitution. Infractions that he has mentioned have not been tied to any breaches of ODM constitution.
Mr. Okero, I think you're muted. I think you're muted or we've lost you. Either muted or we have lost you.
Are you able to hear me now?
Yes, we can hear you now. We lost you at, you've not shown how the infractions are tied to the breach of the ODM constitution. We have lost you again. We have lost you again. Mr. Okero?
I can see that the microphone I'm using is failing. I'm trying to recharge it. If you would just give me a minute, I will log in on a different gadget. I beg your pardon.
Okay, very well.
Thank you. You're able to see me and hear me now?
Yes.
Okay, I must apologize for that.
Send.
Yes, Your Honor, if I may continue. It is curious that Mr. Omondi would submit that the infractions he claims were made by the complainant were of such severity that public interest justified the NEC's to remove him, because this then breach of the party's constitution to satisfy that cannot be lawful. Honorable Kajoin has cited